Good morning, everyone. Thank you for joining, and also thanks for the introduction. I think I'll do without a further introduction of myself. I think that's for the moment unnecessary. That would only take away time from the Q&A session, which I think would be regrettable. There's a lot to discuss, I think. So let me start by saying that Dr. Nguyen and I greatly appreciate this opportunity to present our report, The International Law of the Sea and the South China Sea Disputes. And we thank the China Knowledge Network for providing us with this opportunity. It goes without saying that the situation in the South China Sea is extremely complex, raising numerous questions concerning the interpretation and application of international law in a contested geopolitical setting. As our report submits, the law of the sea, which is one of the fundamental parts of international law, has had a profound impact on geopolitical developments in the South China Sea. Let me explain. The development of the law of the sea in the second half of the 20th century, and in particular the extension of coastal state jurisdiction beyond the territorial sea through the regimes of the exclusive economic zone in the continental shelf, has radically transformed the geopolitics of the ocean. Into the middle of the 20th century, the law of the sea was mainly characterized by the dichotomy between the territorial sea and the high seas. While the sovereignty of the coastal state extended over the territorial sea, the high seas beyond the outer limit of the territorial sea were open to all states on an equal basis under the principle of the freedom of the high seas. Due to the limited extent of the territorial sea, the large majority of the ocean was subject to the regime of the high seas. Currently, the situation is quite different, as you also see on the screen. About half of the ocean is subject to coastal state jurisdiction. As I said, this is illustrated on screen now. And so the lighter areas, the lightest area, that's the international seabed area, and also, so that's a regime with internationalized regime which exists next to the high seas. But otherwise, most of the about half of the ocean is under national jurisdiction, and it also applies for even a larger part of the South China Sea. And so the South China Sea, in our view, is a key example of the way in which the development of the law of the sea in the second half of the 20th century has impacted on the geopolitics of the ocean. And the main characteristics of this impact may be summarized as follows. The basic law of the sea framework is provided by the United Nations Convention on the Law of the Sea, adopted in 1982, or also for short, and that's the acronym we'll be using, the UNCLOS. All coastal states of the South China Sea are parties to the UNCLOS. 4 of these coastal states, China, Malaysia, the Philippines and Vietnam, have sovereignty claims over all or some of the islands located in the central part of the South China Sea. And that includes the Paracel Islands, which you see at the top side of the slide, and also the Spratly Islands, which are at the southern end of the South China Sea, and also Scarborough Shoal, which is to the west of the Philippines island of Luzon. Not sure where you can see it there, but it's also indicated, so it's to the north of the Spratly Islands. So China claims sovereignty over all of these islands, Vietnam over the Paracel Islands and the Spratly Islands, while the Philippines and Malaysia have claims over specific islands in the Spratly Islands, and the Philippines also claims sovereignty over the islands on Scarborough Shoal. Due to their location, the Paracel Islands, the Spratly Islands, and the islands on Scarborough Shoal potentially have a huge impact on the political geography of the South China Sea. The UNCLOS provides that islands in principle have the same maritime zones as continental territory. And as already mentioned, beyond the territorial sea, coastal states have an exclusive economic zone and continental shelf. The latter, which gives the coastal state rights over the seabed and subsoil, may even extend beyond the 200 nautical mile limit of the exclusive economic zone, where the relevant criteria of Article 76 of the UNCLOS, which defines the continental shelf, are met. And this latter situation also is the case in the South China Sea. If we were to exclude the Paracel Islands, the Spratly Islands and the islands on Scarborough Shoal from the picture, the central part of the South China Sea would be beyond the combined outer limits of the exclusive economic zones of the coastal states. So on screen that's the large area in the middle of the South China Sea. So under this scenario where you do not take into account of the Spratly Islands and the other islands, that area would be high seas, and this is a considerable part of the South China Sea, as also shown on screen. From its northern to southern extremity, this high seas area measures some 750 nautical miles, while from east to west its widest extent is around 220 miles. Most of the seabed and subsoil of this high seas area likely is part of the continental shelf of the surrounding coast. And as a glance at the map also indicates, when only considering the surrounding coasts, the Philippines and Vietnam have by far the most extensive exclusive economic zone and continental shelf. And China's maritime zones, and that's very critical under this scenario, are limited to the northern part of the South China Sea, while Brunei, Indonesia and Malaysia are limited to its southern part. If the Paracel Islands, the Spratly Islands and the islands on Scarborough Shoal were found to be islands that are entitled to an exclusive economic zone and continental shelf, the potential extent of coastal state maritime zones would change radically. You see that? Hey, what's happening here? Did I do that?
But the PowerPoint has a black screen.
Yeah, that's right. That's in between slides. So now on screen you have the situation where which in a way explains the impact of the Paracel Islands, the Spratly Islands and Scarborough Shoal is not indicated. It's the green dot to the west of Luzon again. But so you can see that if you give these islands their maritime entitlements, they would have potentially a huge impact on the extent of coastal state zones. So and one implication is the exclusive economic zone of these islands would imply that most of the high seas area I described previously, and you also on the previous screen, would instead be part of that exclusive economic zone of the islands. And in addition, the exclusive economic zone and continental shelf of the islands would overlap with the same zones of the coast surrounding the South China Sea. And this situation, of course, would give the state that has sovereignty over the Paracel Islands, Spratly Islands and islands on Scarborough Shoal potentially coastal state rights over the larger part of the South China Sea. But then the central question is, are any of these islands entitled to an exclusive economic zone and continental shelf to start with? This is where China and the other claimant states part ways. While China takes the position that all these islands indeed are entitled to an exclusive economic zone and continental shelf, this is rejected by the other coastal states. The latter position is based on Article 121, paragraph 3 of the UNCLOS, which provides, and I quote, "Rocks which cannot sustain human habitation or economic life of their own shall have no exclusive economic zone or continental shelf." In addition to this, China and the other claimant states differ over the basis for determining coastal state rights. While the other claimant states hold that coastal state rights are exhaustively defined by the UNCLOS, China has contended that its claims find support in international law beyond the convention. China has also defined the extent of its maritime claims with reference to a line that has, among others, been referred to as the 9- and more recently the 10- line. And Dr. Nguyen will be discussing these issues in more detail subsequently. The positions of China and the other claimant states have in particular been clarified by two events. In 2009, Malaysia and Vietnam submitted information on the outer limits of their continental shelf beyond 200 nautical miles to the Commission on the Limits of the Continental Shelf, or CLCS, in accordance with Article 76 of the UNCLOS. These submissions indicated that Malaysia and Vietnam considered that Paracel Islands, Spratly Islands and Scarborough Shoal do not have a continental shelf. And this is illustrated by this slide. I'm not sure how clear it is on this screen, but there is a red line identifying the outer limit of the 200-mile zone of Vietnam. And as you can see, it does not take into account the Paracel Islands and the Spratly Islands, and also Scarborough Shoal, because no, it's the Paracel Islands and the Spratly Islands that are within 200 miles of this limit. And also, if they were taken into account, there would be no need to make a submission to the CLCS, because there would be no continental shelf beyond 200 nautical miles. So this was a very clear signal about the status of the islands. So they are considered basically to be rocks in the sense of Article 121 paragraph 3 of the UNCLOS. In reaction to the submissions of Malaysia and Vietnam, China issued diplomatic notes in which it submitted that the islands claimed by it are fully entitled islands. And that was also accompanied by this map, which also shows the 9-dash line. So that also indicates the extent of this claim and the impact it has on maritime islands entitlements of other states. So this was the first key event clarifying the positions of coastal states, claimant states in the South China Sea. And the second event, of course, was the South China Sea arbitration initiated by the Philippines against China in 2013. China from the outset vehemently opposed the initiation of the arbitral proceedings, and by that stance, of course, also arguably signaling the potential importance of the outcome of the arbitration. The 2016 award on merits made a number of critical findings in relation to the interpretation and application of the UNCLOS. Combined, these findings imply that China does not have coastal state rights over most of the southern part of the South China Sea. At most, in case the sovereignty disputes over the Spratly Islands and the islands on Scarborough Shoal were to be resolved in China's favor, China would have sovereignty over the territorial sea only of the features concerned, but not beyond the territorial sea. China's argument that the award is null and void and its continued reliance on legal arguments that have been rejected by the award imply a continued disagreement about the basic rules of the road for the South China Sea, largely frustrating meaningful cooperation on the sustainable use and conservation of the South China Sea. As we indicate in the report's introduction, it is intended to critically analyze the current positions of China, in particular in relation to the law of the sea as they relate to the South China Sea. The guiding question in this respect is to what extent these positions are in line with the law. Although our analysis is not exhaustive of all relevant issues, we consider that our coverage is sufficiently comprehensive for drawing general conclusions on the relevance of the international law of the sea for the South China Sea disputes. For our current presentation, we had to make some further choices as regards the issues we'd like to discuss. Dr. Nguyen will first address the grounds that have been advanced by China in rejecting the South China Sea arbitration. Next, she will visit the implications of that rejection, namely China's argument that the awards resulting from the arbitration are null and void. Finally, she will discuss how China, despite rejecting the arbitration's interpretation of the UNCLOS, at the same time is trying to move away from the UNCLOS and instead is seeking to rely on customary international law to justify its claims. I will then provide an overview of the challenges ASEAN member states and China may be facing in negotiating a code of conduct to manage their relations in the South China Sea. And at this point, let me stress that during the Q&A, after our presentation, we welcome questions on any of the issues discussed in our report. And as you may have noted in the invitation for this presentation, our talk would also discuss the, and I quote, competing sovereignty claims over the Paracel Islands, Spratly Islands and Scarborough Shoal and give recommendations for policymakers and stakeholders engaged in the region's legal and diplomatic processes, end of quote. That, however, only will be the case to a limited extent, but we are available to try answering any questions you may have on these issues. Before giving the floor to Dr. Nguyen, let me briefly summarize the main findings of the report. As we submit, China's posturing in the South China Sea arguably poses a fundamental challenge to the UNCLOS. This challenge is due to the fact that the rules on maritime zones contained in the Convention, which provide the cornerstone of the legal and political order of the ocean, do not support China's interest in gaining access as a coastal state to the southern part of the South China Sea. At the same time, China does not seem to be challenging the relevance of the law as such, another issue that will also be elaborated by Dr. Nguyen. Its policy instead has been to rely on the law to justify its positions, but through a distorted interpretation of the law and through blurring the line between legally binding and non-legally binding rules, such as political commitments, to create space for the advancement of its claims. China seeks to build a framework that's loosely based on the language of international law, but subject to its own understanding and interpretation. Consequently, there is a fundamental disagreement between China and other claimant states about how the international law of the sea defines the political geography of the South China Sea. And as long as that disagreement persists, it is unlikely that meaningful cooperation going beyond the level of crisis management will be possible. The law of the sea and international law generally offer the coastal states of the South China Sea a framework for assessing each other's claims about the political geography of the South China Sea. Coastal states may take that assessment into account in deciding on their policy options. And the South China Sea arbitration, for its part, has played an important role, as already said before, in clarifying some of the key legal issues which are central to the South China Sea disputes. As such, even though China continues to reject the arbitration, the findings of the arbitral tribunal provide an important authoritative reference point for other claimant states to continue to rely on the UNCLOS to object to China's legal claims and China's actions on the ground. Finally, the legitimacy pool of the awards can only be effective, however, if they continue to be upheld by the international community. States supporting the legal order created by the UNCLOS should continue using the arbitral awards as a reference point in their foreign policy relating to the South China Sea. This concludes my introductory remarks. I now give the floor to Dr. Nguyen.
Thank you, Professor LL.M, and good morning, everyone. So as mentioned, I will spend the next 20 to 25 minutes discussing China's rejection of the South China Sea arbitration and the implications of this rejection, as well as some of the developments that have taken place in the aftermath of the arbitration. So I thought it would be a good idea to focus on the South China Sea arbitration because, as Professor LL.M has mentioned, it is one of the key milestones in terms of legal clarification in the context of the South China Sea disputes. So this is, I guess, something that we're all familiar with, but just to set the background, the Philippines initiated the arbitral proceedings following the rules of Part 15 of UNCLOS. And this is important to mention because this means that the arbitration has to follow the rules of this part, and that means that the tribunal can only exercise its power to hear the Philippines dispute if the requirements in Part 15 are met. And it is based on these procedural requirements that China has built its rejection of the arbitral award. And so after the arbitral award was rendered, China has consistently declared that the award is null, or the awards are null and void and without binding effect on it, and it has publicly declared a 4 no's policy: no participation, no recognition, no acceptance, and no compliance. And to date, this is still the official position of the Chinese government. So official statements from the Chinese government have laid out 3 main grounds for rejecting the arbitral awards, and you can see them on the screen here. First is that the arbitral tribunal was illegally constituted without China consent and participation. Second, that the arbitral tribunal went over and went beyond the mandate that was given to it under the convention. And that third, that the arbitral tribunal was not a legitimate international court. And this picture that you see there is, of course, the composition of the 5 arbitrators of the South China Sea arbitration. So in our report, we argue that none of these arguments stand up to scrutiny under the law of the sea and international law. And of course, due to time constraints, I will not be able to deal with each of them. And I invite those that are interested to take a look at the detailed analysis in the report. For the purposes of this presentation, I will mention briefly some key points. So the first, China's consent and participation. The first question is, of course, has China consented to arbitration? And the answer here is yes, because UNCLOS creates or includes a compulsory dispute settlement system. And the jurisdiction or the power of the tribunal under UNCLOS to decide on the case is automatic when a state becomes a party to the convention. And China ratified the convention in 1996 and therefore became a party to the convention, thereby also giving its consent to the tribunal. But China did not participate at all in the proceedings officially. There were still position papers on the sideline, but officially it did not participate. So the question is then, of course, does China's non-participation amount to a withdrawal of consent? And the answer here is no, because even though non-participation does happen from time to time, there is no obligation for a state to appear before an international court. And non-participation basically just means that the state has given up its right to defend itself before the arbitral tribunal in question. And Annex 9, the text of which you can see here, Article 9 of Annex 7 of UNCLOS also already envisions this situation where a party does not participate. And there it says that that situation shall not constitute a bar to the proceedings. And so that means that whether or not a state is a party to the case, whether or not the outcome of the case is still binding on that party does not depend on participation. It depends on whether consent has been given. And as we just mentioned, China has done so. And thus in this case, its non-participation does not mean that China has withdrawn its consent, and China therefore remains a party to the case. Now, with the second set of arguments that China has advanced, that the tribunal went beyond the scope of its power, China has put forward 4 arguments as recent as just this year, or last year actually, 4 lines of argumentation to reject the arbitral tribunal's findings. And the first one is that the tribunal dealt with a territorial sovereignty dispute. And the reason why this argument was put forward is because under Article 288 of the Convention, a law of the sea tribunal can only deal with law of the sea disputes, and territorial sovereignty is not one of them. And this is what the tribunal did, as according to China. However, while indeed, as Professor L.L.M mentioned, there exists a sovereignty dispute between the Philippines and China, the tribunal found that the resolution of the Philippines' claims does not require the tribunal to deal with sovereignty issues either explicitly or implicitly. And China has frequently referred to 2 cases in which, when faced with a territorial sovereignty issue, those 2 tribunals decided to not go forward with the case. And it criticized the tribunal for adopting a very different approach. But it's worth mentioning here, as we analyze in the report, the case or the submissions of the Philippines were distinct from those of the other 2 cases. The second argument here is that the tribunal exercised jurisdiction over maritime delimitation disputes. And this argument is built upon this particular provision of UNCLOS Article 298, which allows all parties to UNCLOS, including China, to exclude maritime delimitation disputes from the jurisdiction of the tribunal. And maritime delimitation includes the drawing of bilateral boundary between 2 states. However, in this case, the Philippines did not request the tribunal to engage with maritime delimitation. It did not request the tribunal to draw a maritime boundary. It only requested the tribunal to deal with maritime entitlement, meaning it only requested the tribunal to determine whether the features in the South China Sea were entitled to a territorial sea, exclusive economic zone, or continental shelf. But in China's view, maritime entitlement is part and parcel of maritime delimitation. You cannot separate them. And when you are engaged, or when the tribunal is engaged with maritime entitlement, it is also engaged with maritime delimitation. However, in our view, in our report, we conclude that the tribunal's finding that there was no maritime delimitation dispute in question, that approach was correct. If you look at the wording of Article 298, you will see that its word plainly only refers to Articles 15, 74, and 83, all of which relate to sea boundary delimitations. And indeed, the drawing of maritime boundary is premised upon the existence of overlapping maritime entitlement, but these articles themselves do not concern maritime entitlement. Maritime entitlement is regulated by other provisions of the Convention, which are not included in Article 298 here. The third argument is that, and this argument will, we will see the repercussions in the discussion on the COC later, is that in China's view, the tribunal infringed upon the the parties' right to settle disputes through peaceful means of their own. And this is a right that's guaranteed under the Convention under Article 281, as you can see here. So the main argument here that China has put forward is that under the Declaration of Conduct, paragraph 4, the parties have agreed to settle disputes through various means. And the agreement that the parties have agreed under paragraph 4 of the DOC have to take priority over UNCLOS. And in this particular instance, China has argued that the South China Sea arbitration has adopted an interpretation of this Article 281 that's very different to a prior arbitral tribunal's decision, the Southern Bluefin Tuna case, which would have favored China. However, our analysis conclude that even though, indeed, the interpretation of Article 281 of the Southern Bluefin Tuna and the South China Sea tribunals are different, but if we were to apply both of these reasoning to paragraph 4 of the DOC, the outcome would still be the same, and that is that paragraph 4 will still not exclude the Philippines from going to UNCLOS to settle the dispute. And then last but not least, the tribunal in the South China Sea also found that all high tide features in the Spratly Islands are ROPS, and that the Spratly Islands cannot claim maritime rights as a whole. And these are issues that were not raised by the Philippines in its submission. So in the aftermath of the tribunal of the arbitration, China had advanced an additional, the fourth argument, that by saying so, the tribunal had violated a principle of international law which prevents international courts from deciding issues that were not put forward by the parties to the case. This principle, however, in our view, and as has been affirmed and in previous cases before other international court, does not preclude the court from deciding legal points in its reasoning where it deems this necessary. And in the South China Sea case, the tribunal, when holding and when finding these issues on the Spratly Islands, had to do so in order to determine whether it has jurisdiction over another submission. So in our case, there was no violation of the principle that China had alleged. And then last but not least, we will not go through all of this, but the Chinese government officials and scholars have frequently conducted personal attacks at different individuals of the arbitral tribunal, as well as the judge who appointed the arbitrators, because China did not participate. But if we look at the rules of UNCLOS, we'll see that these personal attacks actually do not hold up to scrutiny. So, taking all of this into account, despite China's rhetoric, the arbitral awards are still binding upon the parties to the case, and this is what is guaranteed under Article 296 of the Convention. But if we zoom out a little bit from the arbitral tribunal's findings and we take a broader look, broader perspective at third-party dispute settlement, we'll see that at the core of China's objection to the South China Sea arbitration is the fundamental opposition to using third-party settlement to deal with territorial and maritime disputes. And this strong stance has already been put forward by China during the negotiation of the UNCLOS, and even more recently in the negotiation of a new agreement on law of the sea, the agreement on conservation of biodiversity beyond national jurisdiction. So this is a very consistent, strong stance that China has expressed over the past decades. While China's position towards the arbitration has been one of consistency, albeit questionable from a legal perspective, changes in the governments of the Philippines since the tribunal, the arbitration concluded, have resulted in inconsistent policies and approaches to the arbitral awards. So if we combine China's strong and hard stance against third-party settlement, the inconsistent position of the Philippines towards the arbitration, the asymmetry in power between the two parties, as well as the lack of enforcement mechanisms under international law, this may indicate that the arbitration has exerted little compliance pull towards the parties, especially on China, and has resulted in little change in the Chinese behavior on the ground. And this, coupled with the costs associated with resorting to third-party settlement, this may present a discouraging precedent for other states in the region to resort to third-party settlement. However, as Professor Alfred has alluded to, in our view, this does not mean that the arbitration was without impact. The award has assessed China's legal arguments and make it problematic for China to continue to rely on positions that are not in accordance with UNCLOS. And in that sense, we see that the arbitration has exerted what is called as a legitimacy pull, regardless of the issue of noncompliance. So in the remaining part of the presentation, I'd like to look at the extent to which this legitimacy pull has manifested in the aftermath of the South China Sea arbitration. So, as we already know, China's position remains that the South China Sea arbitral awards were null and void. And as we already mentioned, while legally speaking, the legal basis for such claim is unsound, the fact remains that such position has a practical impact on the scope of the South China Sea dispute. And amongst the impact, perhaps the most important one is on the scope of the spatial scope of the disputed maritime areas in the South China Sea. Because of course, defining which areas is under dispute and which are not lays the ground for a lot further actions. If China continues as it does to reject the arbitral awards, it can continue to advance claims as though the awards did not exist. So it continues to advance claims based on its historic rights in the South China Sea, based on the fact that all the features in the South China Sea can claim extensive maritime zones, while other states, on the other hand, have been using the awards to determine the areas under their respective jurisdiction, rejecting China's expansive claim to define the remaining disputed areas. So the question that remains here is which rules apply when states in question do not agree on the scope of the disputed maritime areas? And in this particular case, what role should be given to the arbitral award in defining the disputed maritime areas? The test that international courts have been using in this regard in order to determine whether a state is capable of advancing a claim to a maritime zone is one that's known as the plausibility test. In applying this test, for example, the tribunal in the case between Ukraine and Russia considered whether the claim of one party is a mere assertion or one which was fabricated solely to defeat jurisdiction. So if we were to apply this test to the case of the South China Sea, it seems clear that this is not the case. China's claim in the South China Sea, expensive as they may be, were not fabricated only to defeat jurisdiction. Can they be considered mere assertions? They are assertions to the extent that their legal basis is questionable, but these assertions have been supported by repeated concrete actions on the ground. So it seems that it doesn't apply. In a different case, the International Tribunal for the Law of the Sea took into account the fact that there already existed a prior judicial decision which provides authoritative determination of the parties' claims to establish whether the claims had merits. And in this case, with the arbitral awards, that would seem to be the case. However, it is our view that there does not seem to be any basis at the moment under international law for applying the plausibility test beyond court proceedings. In practice, there's no legal rule providing that a state has to accept the claim of another state to define the disputed maritime areas. A state, in considering the position of another state, is required to act in good faith. But the reality is that that does not entail an obligation for states to accept that claim. What then remains at the moment is a stalemate, even with the arbitral awards in place. Another development to examine the legitimacy pool of the arbitral award is China's turn to customary international law. Since the 2016 award of the South China Sea arbitration was rendered, China has increasingly shifted towards away from the UNCLOS and has given more weight to customary international law, and that's written law that is established through state practice to justify its claim in the South China Sea. So while repeatedly rejecting the arbitral awards, this turn to customary international law suggests that China is in fact not completely ignoring the awards. Rather, it is responding to the tribunal's findings in its own way, not by abandoning the inconsistent claim, but by finding a different legal basis to justify its claim. So in essence, China's current position is that UNCLOS is not the whole of the maritime order, and that customary international law continues to govern the law of the sea issues. And customary international law is particularly pertinent to China's two key claims in the South China Sea, namely claims to historic rights and claims relating to dependent archipelagos in continental states. So let's take a look at them, each of them briefly. So as regards the first, historic rights in the South China Sea, to recall, the South China Sea arbitration conclusion was that China's historic rights claim was in violation of UNCLOS. And in response, China has started advancing the argument that historic rights are mainly regulated under customary international law, not regulated by the convention. So it is true that historic rights are regulated under customary international law. But the South China Sea Arbitral Tribunal has found that they no longer exist in the exclusive economic zone and continental shelf with the entry into force of UNCLOS. In other words, any historic rights that a state would hold in the EEZ of another state would have been succeeded by the coastal state's sovereign rights in these maritime zones. So any historic rights that would have existed in what would have been Vietnam or the Philippines EEZ would have now been superseded by their own sovereign rights under the convention. In addition, in order for historic rights to exist, then they need to meet the requirements under customary international law, and that is the continuous exercise of claim rights and the acquiescence of other states that are affected. And China's historic claims in the South China Sea does not meet these two requirements. There is no evidence suggesting that China has historically regulated or controlled fishing in the South China Sea beyond the limits of the territorial sea, and there was no acquiescence from other states. And thus, China's claim to historic rights in the South China Sea, even if under customary international law, does not hold waters. In the same vein, in response to the tribunal's findings that none of the features in the South China Sea are islands or rocks entitled to, in the Spratly story, are islands and rocks entitled to their own exclusive economic zone and continental shelf, and the finding that UNCLOS does not permit enclosing within Strait Baseline offshore archipelago where claimant state has a separate mainland, China has been pivoting its basis to the concept of Nanhai Chutao. So the term Nanhai Chutao, or South China Sea Islands, comprehensively refers to maritime features in the South China Sea as indicated here on the map. So there are 4 groups of islands that you will see enclosed in the Strait Baselines here. In 2024, China stated that it had maritime rights over the Nanhai Chutao as a unified whole. So while China had referred to the 4 separate archipelagos in its domestic legislation and in other documents before 2016, so for example, if you see here the map that it included in its note verbal in 2009, you do see these 4 separate groups of islands on the map as well. But it's only since 2016 that it has started to treat these 4 islands as a unified, 4 groups of islands as a unified whole under the concept of Nanhai Chutao, and pushing this concept to the fore. So the import of the reliance on the concept of Nanhai Chutao remains somewhat unclear. One way to understand it is that China treats all of these islands as a group and wants to draw a straight baseline along all of them. But as far as can be certain, this has not been China's arguments, and indeed there would be no basis under international law for making such an expansive claims. And out of these 4 groups of islands here, what China has done is to establish straight baseline only around the individual groups of islands, and that's the Paracel Islands here. Strait baseline are regulated under the Law of the Sea Convention, and they have to meet the requirements of Articles 7, 46, and 47 of UNCLOS. And our analysis indicates that the strait baselines around the Paracel Islands do not meet the requirements of these articles. But again, China's argument is that UNCLOS does not establish a comprehensive regime relating to strait baselines, and that baselines for continental states, so that's China, that's with the mainland, and baselines for continental states dependent archipelagos, such as these groups of archipelagos, are regulated under customary international law. And this argument is based on the premise that the preamble of UNCLOS itself states that matters not regulated by this convention continue to be governed by the rules and the principles of general international law. So this premise raises the question, are baselines regulated by the convention? If they're not, then indeed they're regulated under customary international law. And in the case of baselines here, the starting point is Article 5 of the Convention, which provides that the rule is, which provides a rule for drawing baselines that is generally applicable to all coasts, be they of mainland and islands. And Article 5 itself recognizes exceptions to these general rules. So these exceptions pertain to strait baselines that are found in other provisions of the Convention, for example, 7 or 47. So UNCLOS does establish a comprehensive regime with a general rule and a limited number of exceptions to that general rule when it comes to baseline. And this means that in our view, the baseline regime is regulated under UNCLOS, and therefore the preambular paragraph that China relies on cannot be applied to this case. So here you can see the difference between using the strait baselines around the Paracel Islands and the normal baseline that would normally be used here. China further argues that its claim is consistent with state practice, and it points to the fact that approximately 20 continental countries worldwide possess outlying archipelagos like those in the South China Sea, with 17 of them having established strait baselines for outlying archipelagos as a whole, so similar to what you see on this side. However, a survey of the practice of the states, in our view, does not suggest the existence or the emergence of a rule that is different to what's already contained in Article 7 of UNCLOS. Or in other words, the practice of states does not indicate that there is a separate or additional customary law that's different to that that's already been included in UNCLOS. So to conclude my part, the emergence of China's claims based on general international law is a recent development. And it is highly likely that this recent development is partly in response to the findings of the South China Sea arbitration, and these provide some proof that there is some legitimacy pool of the awards. But it is our position that China's claims in the South China Sea cannot find basis under customary law. However, China's turn to customary international law provides a clear illustration of what Professor LL.M mentioned in his introduction, and that is that China does not seem to be challenging the relevance of international law as such. It is seeking rather to build a framework that is loosely based on the language of international law, but subject to its own understanding and interpretation. So thank you very much for your attention, and now I give the floor back to Professor LL.M.
Yeah, thank you, Dr. Nguyen. So briefly about the code of conduct, which of course is not yet finalized. So where are we at with the negotiations of a code of conduct in the South China Sea? The idea of such a code of conduct has been around since 1992. In 2002, China and ASEAN member states concluded the Declaration on Conduct of the Parties in the South China Sea, a legally non-binding instrument. Apart from agreeing on rules for managing their disputes, this DOC reaffirmed the commitment to continue working towards the adoption of a code of conduct. More than 20 years later, that work is still continuing. Although little information on the current draft of the code is in the public domain, it is still possible, we find, to make a meaningful analysis of the possible format and content of a future code of conduct. In our report, we look at a number of specific issues which you also have on screen now. So the question, what would be the difference between a COC as a legally binding or non-legally binding instrument? What can you say about the area of application of a future code? What could be the substantive conduct? And how do you refer to the settlement of territorial and jurisdictional disputes? And of course, that's also contained in paragraph 4 of the Declaration of Conduct. This issue, which paragraph 4 of course was already discussed. And finally, we also briefly looked at review mechanisms for the implementation of a COC. For now, I will briefly review the first 3 of these items. As regards the first item, the report concludes that the choice between a legally and non-legally binding instrument generally is of limited significance. First, it is likely that there will be little to no further elaboration of already existing legally binding commitments. Moreover, those commitments provide a quite detailed framework for managing activities and incidents in the South China Sea. And this then raises the question whether adding another layer to that framework would substantially change the situation on the ground, lacking the political will of all parties to do so. However, adopting a legally binding code would be crucial in one respect, we submit, because a legally binding code would become part of the assessment framework for determining whether a state party to the UNCLOS is entitled to unilaterally invoke the compulsory binding dispute settlement provisions under Part 15 of the Convention. Due to the opposing views of the negotiating parties on this issue, so that is China on the one and other claimant states on the others, among others, it is likely that a COC will contain ambiguous language that allows reading both views into a compromise text. However, the crux of the matter would be that in case a dispute is unilaterally submitted to binding dispute settlement under the UNCLOS, it would be that the dispute settlement body involved that would have the power to interpret the relevant provision of a COC, and not an individual party to a COC. And this is explained by Article 288, paragraph 4 of the UNCLOS, which reads, and I quote, "In the event of a dispute as to whether a court or tribunal has jurisdiction," so that's jurisdiction in the Convention, "the matter will be settled by decision of that court or tribunal," end of quote. So in that case, that body would have to choose one specific interpretation of the pertinent provision of a COC in determining its jurisdiction, lifting the veil of ambiguity that states can maintain in the absence of compulsory dispute settlement. And in this respect, it's also interesting to note that China rejects the South China Sea's arbitration's interpretation of the DOC on this point. The tribunal found that the language in the DOC did not restrict recourse to compulsory dispute settlement. Under the UNCLOS, as also indicated by Dr. Nguyen, our report submits that this conclusion would also apply in case the stricter test of another arbitration, southern bluefin tuna, would be applied. I mentioned this latter point, and it was also mentioned by Dr. Nguyen, because sources supporting China have been relying on the latter case to criticize the finding of the tribunal in South China Sea. Turning to the second item in my list, another complex issue, defining the area of application of a code. Let me explain why that is a complex issue. And at the outset, let me also point out that this issue links to Dr. Nguyen's general discussion of defining disputed maritime areas. And I would say the bottom line in that respect is that there is no legal rule obliging a state to accept that an area is disputed just because another state claims this is the case. With that in mind, let me turn to the area of application of a COC. According to the Philippines and other claimant states, the South China Sea arbitration has authoritatively determined that the southern part of the South China Sea, except for the territorial sea of the Spratly Islands and the islands of Scarborough Shoal, is not in dispute between themselves and China. And so these states can hardly be expected that cooperative arrangements and duties of restraint contained in a code would be applicable to that undisputed area, limiting their rights under the UNCLOS. Similarly, another option, of course, would be not addressing the area of application in a code, but that would similarly put also into question the undisputed nature of most of the southern part of the South China Sea. This may be illustrated by the language that is contained in paragraph 5 of this DOC, which provides that, and I quote, "The parties undertake to exercise self-restraint in the conduct of activities that would complicate or escalate disputes and affect peace and stability." Assuming that a COC would not address the status and implications of the South China Sea arbitration, and it would seem to be beyond imagination that a COC actually might do so, a commitment similar to paragraph 5 of the DOC would imply that China could argue that the Philippines, in exercising its rights in accordance with the UNCLOS as confirmed by the tribunal, would be acting in breach of the commitment contained in paragraph 5 of the DOC, if a similar commitment was in the ACOC. Why is that so? It's explained by the fact that under such a scenario, the Philippines would be carrying out activities in an area that, according to China, is disputed, and the Philippines consequently would complicate or escalate its maritime disputes with China. And that is already an issue is illustrated by recent incidents related to the Sierra Madre, that's a Philippines vessel at 2nd Thomas Shoal, in which case China is accusing the Philippines, which is carrying out these operations that are in accordance with the UNCLOS and the arbitration, of acting in breach of undertakings contained in the DOC. Let me also briefly comment on the substantive issue areas that may be included in a code. A couple of challenges would seem to exist in this respect. Taking the DOC as a starting point, it may be noted that the areas for cooperation the DOC lists do not include either living resources or non-living resources, although the control over their exploitation and management is one of the issues that is at the heart of the South China Sea disputes. And the raison d'etre of both the exclusive number zone and the continental shelf, which covers most of the South China Sea, mostly is giving the coastal state sovereign rights over these resources. This at the same time points to the difficulty in developing cooperative activities in respect of natural resources. In view of the wide gap between the positions of China and the other claimant states as regard their rights as coastal states or otherwise, think China's alleged historic rights, it is difficult to envision a collaborative scheme that bridges this gap without compromising the position of one or both sides in practice. Our main submission on a code of a future code is that it's not likely that it would significantly reinforce dispute management in the South China Sea. However, a future code is a political project to which ASEAN member states and China have committed themselves time and again after their initial agreement to work towards a COC in 2002. So it would seem to be impossible for either side to extract itself from that commitment without paying a high political price. Seemingly the choices that remain are letting the negotiations drag on or conclude a COC that will most likely look much like the current DOC. And even in that case, as my talk should have explained, there are certain challenges to finding an appropriate text. So that finalizes our presentation of the report, and we thank you for your attention, and of course we look forward to your questions. Thank you.